Good afternoon. For those of you I didn't see this morning, my name is Jeff Follansby, and I serve as a Vice President of Chautauqua Institution and the Chief Executive Officer of the Chautauqua Foundation. And I'm very pleased to welcome you to the Hall of Philosophy this afternoon for this important lecture today featuring the Honorable Jon O. Newman. We have been partners with the Jackson Center in Jamestown for 12 years now in terms of the delivery of this Jackson lecture. And I'd ask you to help me thank the Jackson Center for their support and their participation and partnership in providing this lecture each year. Judge Newman is going to be introduced by John Q. Barrett, who is a professor of law at St. John's University, where he teaches constitutional law, criminal procedure, and legal history. Professor Barrett has produced extensive scholarship on Justice Jackson, and he serves as the Elizabeth S. Lennay Fellow at the Robert H. Jackson Center. He is a graduate of Georgetown University and Harvard Law School. And without any further ado, as they say, I give you Professor John Barrett. And try not to kill ourselves here.
Thank you so much, Jeff. Good afternoon. Long time no see. It's always a pleasure to be back at Chautauqua. This was a quick interval since I had the privilege to lecture here a couple of weeks ago. My task this afternoon is a high honor and a high responsibility, to be brief. So I will briefly address three topics: Robert Jackson, this lecture, and Judge Jon Newman. Robert Jackson, of course, was a native of this region, a lawyer in Jamestown, New York, a leader in the American legal profession, and then a New Deal presidential appointee who became the Attorney General of the United States and a U.S. Supreme Court Justice. As if that weren't enough, he skipped away from the Supreme Court for a year and served as the chief American prosecutor of the Nazi war criminals in Nuremberg, Germany during 1945-1946. But on top of all of that, I think it's fair to say, Robert Jackson was a Chautauquan. He never went to college. After a 13th year, a second senior year of high school, his path to the bar was mostly as an apprentice. So a lot of his higher learning was on these grounds and in the environment of this institution and this region, and the speakers he heard and learned from, William Jennings Bryan, many others, and the opportunity to be a Chautauqua speaker. I want to focus for a second on July 4, 1947, 70 years ago. It was the last time Robert Jackson gave a major speech at Chautauqua in the amphitheater. And his topic was the fears of the impending World War III at that moment. Now, 70 years maybe isn't such a great distance. Robert Jackson, on that 4th of July 70 years ago, spoke in very consoling, optimistic terms about American history and the potential, even in that deep moment of the Cold War, to have hope that diplomacy and leadership and communication would be a continuing path to peace. And he knew this somewhat directly because he had spent a year side by side and as a counterpart with Soviet colleagues at Nuremberg. And so Robert Jackson, with his brilliance, his judicial career, his service, and his accomplishments, was an enduring voice of hope at Chautauqua. Topic 2, this lecture, I think is in that tradition. The Supreme Court of the United States, on which Jackson served with great distinction from 1941 until the fall of 1954, is an institution that takes, of course, a summer recess. A good job if you can get it. And Chautauqua Institution takes summer action, if you will. And Jackson as a Chautauquan, the Supreme Court as a perpetually significant topic, the Chautauqua season as a summer moment to take stock of the Supreme Court, was the genesis of this lecture, which the Jackson Center has assisted Chautauqua Institution in hosting for the past 13 years. And this podium and these Jackson lectures on the Supreme Court have hosted a succession of great luminaries, profound thinkers, deeply experienced and engaged participants in one way or another in the life and work of the Supreme Court, and voices who become an important part of the Chautauqua conversation. It's particularly a fit this summer, and was particularly a fun thing to plan because there was already a theme week in week 5 on the Supreme Court, and this lecture, in a sense, caps or continues or closes that. Which brings me to topic 3, today's lecturer, who is a capper or a topper or just an all-star. Judge Jon Newman, a native of Connecticut, is a graduate of the Hotchkiss School and Princeton University and Yale Law School, and then served, because of his high academic achievements, as a law clerk to 2 very distinguished federal judges, Judge George Washington, yes, really, Judge George Washington of the D.C. Circuit, and then Chief Justice of the United States Earl Warren in 1957, 1958. Thereafter, Jon Newman returned to Hartford and began law practice, but also quickly through Democratic political activity became an important aide and protege of Governor, become Cabinet Secretary, become U.S. Senator Abraham Ribicoff. And the Ribicoff relationship, in time, was political support for the series of presidential appointments that has been Jon Newman's career path. Private practice didn't last that long. He became the United States Attorney in Hartford, Connecticut. And then in 1971, he was appointed a United States District Court judge in the District of Connecticut, the federal trial court. And after about 6 years as a trial judge, he was appointed to be a United States Court of Appeals judge for the Second Circuit, the Federal Court of Appeals, one rung below the U.S. Supreme Court, in the circuit that encompasses the 3 states of New York, Connecticut, and Vermont. An incredibly important jurisdiction and incredibly weighty responsibility to decide the cases. And Judge Newman has been a judge of that U.S. Circuit Court of Appeals ever since. He served a term as the chief judge of the court, and although today he is in, quote, senior status, he is still a very active, very important jurist contributing to the work of that court on a year-round basis, sometimes from New York and sometimes from Florida. Jon Newman is a giant of the federal judiciary. It's captured in a number of respects. One is a moment that didn't occur, but I think is fair to flag. In 1993, newly inaugurated President Clinton had a resignation by Justice White and an opportunity to appoint a Supreme Court justice. And if one can believe the press reports, which in fact are true, President Clinton quickly, after a number of interviews and consultations, settled on a list of 2 finalists, Stephen Breyer and Jon Newman. And for personal circumstances, largely, Judge Newman said, "This isn't for me." And he took himself out of the running. Now, in the short term, that didn't help Judge Breyer, then of the First Circuit, because President Clinton hadn't loved him on their first meeting. And so President Clinton then returned to someone who he also had not loved on their first meeting, then Judge Ruth Bader Ginsburg. And he loved her a lot more the second time, and you know the story from there. And the next year, when President Clinton had a second vacancy, Jon Newman still had withdrawn from the running, and things worked out better for Stephen Breyer. But serving on the Supreme Court, wonderful gig, summer vacation, etc., that it is not the only measure of the greatest of our federal judges. One other tangible, objective honor that shows this is something called the Devitt Award, which is an insider's honor in the legal profession. It's conferred on a kind of lifetime achievement, greatness basis to a member of the federal judiciary. It's really the Hall of Fame of the federal judiciary. And at the Supreme Court of the United States earlier this year, Jon Newman was awarded the Devitt Award to honor his many decades of service to the federal judiciary, which are an ongoing contribution to what makes this country great and what makes one, I think, properly optimistic about this country's future. So it's a real pleasure to introduce the 13th annual Chautauqua Institution Robert H. Jackson Lecturer on the Supreme Court of the United States, Judge Jon Newman.
Thank you, John. Fortunately, he was not under oath. It's an honor to deliver a lecture named for Justice Robert Jackson, to do so at this historic podium, and to follow the distinguished roster of lecturers who preceded me. Preparing for this event, I noticed that many of my predecessors expressed the view that Robert Jackson was their favorite justice. Well, I want the record to show that I not only share that view, I have evidence that I held it long before Professor Barrett's kind invitation to deliver this lecture. In a passage I wrote many years ago for my memoir, which was published earlier this year, I said, "Jackson, the last person appointed to the Supreme Court who did not graduate from a law school, is my favorite justice, both because of his decisions and his great skill as a writer." And the quote continues, "I regard his opinions as consistently the best written by any justice." I must give credit to my wife, Ann, for suggesting my topic today, comparing today's Supreme Court to the court I knew 60 years ago from the vantage point of a law clerk. As Professor Barrett has told you, I had the privilege of serving as the senior law clerk to Chief Justice Earl Warren during the 1957 term. I'm going to compare the 57 term to the 2014 court. I select 2014 to precede the death of Justice Scalia in 2015, which left an 8-member court during half of that year, all of 2016, and part of this year. The selection of Supreme Court clerks has changed since 1957. In that year, most of the clerks came to the court right after graduating from law school. Only 3 had previously been a law clerk for a year at a federal court of appeals. In 2014, all the clerks had previously worked for a court of appeals judge. The first law clerk came to the court in 1882, but the practice was not institutionalized until several years later. Justices Holmes and Brandeis were the first to hire recent law school graduates, as the one law clerk each was then allotted. Law clerks assist a Supreme Court justice in 3 ways. They write brief memos on the thousands of requests asking the court to review decisions of the 13 federal courts of appeals and the 50 state Supreme Courts. These requests are called petitions for writ of certiorari, cert petitions for short. Law clerks write long memos analyzing each case that the court has accepted for argument, and sometimes law clerks draft opinions and usually edit drafts that their justice has prepared and give suggestions for improving draft opinions from other justices. Law clerks serve for 1 year, although in the court's early years, some serve for several years, a few for the lifetime of their justice. That first task of writing memos on cert petitions has changed since '57. The clerks in the chambers of each justice, except Justice Frankfurter, wrote a cert memo for their boss. And by 2014, a so-called cert pool had been formed, started in '72. The cert petitions were divided up among the law clerks for all the justices in the pool. There were 5 participating in '72. And these clerks wrote just 1 memo on each petition for the entire pool. In some years, as many as 8 justices were in the pool. Today, only Justices Sotomayor and Gorsuch receive cert memos from their own law clerks. I think the cert pool is an unfortunate development. The justices are better served when each receives a cert memo prepared by his or her own law clerk. When 9 clerks prepare cert memos on each petition, as we did, there's a better chance that at least one of them will identify a petition that really should be granted. Now, it's true that in some chambers, the law clerks give their justices comments on the pool memos. And perhaps the cert pool is an inevitable consequence of the huge increase in the number of cert petitions. In 57, there were just 18 law clerks. 7 justices had 2, Justice Douglas had 1, Chief Justice had 3. In 2014, each justice had 4 clerks for a total of 36. The reason Warren had 3 clerks in 57 was our primitive technology. There were no Xerox machines or other means for quickly reproducing copies of documents. So when people without lawyers, called pro ses, asked the court to review their cases, they usually filed just 1 copy of a cert petition, often handwritten. Most of these pro ses were prisoners challenging either their conviction or the conditions of their confinement. With that 1 copy from the pro se, the law clerks for the Chief Justice prepared a short memo, usually 2 or 3 pages, for all 9 justices of the court. We made copies by typing them on carbon sets with 8 sheets of carbon paper between 9 sheets of paper, tissue paper. Very primitive. Our memos were appropriately called flimsies. The 9th copy, it's fair to say, was barely legible. In 2014, the cert memos in pro se cases were prepared by the cert pool. One day during my clerkship, Justice Frankfurter, who, as you may know, had a rather strained relationship with Chief Justice Warren, stopped me in the hallway on the way to my office and told me he wanted me to come with him to his chambers to discuss one of those pro se cert memos I had written. That is, he added with a twinkle in his eye, unless you're quarantined from my chambers. On another occasion, when I had used a colloquial term in a memo, Justice Frankfurter wrote me a note stating, quote, "You have permitted the gaiety of conversation to intrude upon the permanence of print." The increase in the number of clerks has had one consequence not usually reported. If you look at the thickness of the books containing opinions of the Supreme Court, you will notice that as the number of law clerks increased over the years, so did the number of pages of the court's opinions. There were not more opinions, in fact, there were fewer. The opinions just got longer. Law clerks draft many opinions, and justices often do not take the time to edit them down to an appropriate size. A few words about my title, senior law clerk. In later years, it changed to chief clerk. The Chief Justice customarily bestowed the title on the one of his 3 clerks who had been a clerk at a court of appeals. Since I had been a clerk at the District of Columbia Court of Appeals, I got the title. It was not a merit designation. The title carried one perk, a large office all to myself, and the responsibility for choosing the monthly speakers for luncheons at the court with the entire group of law clerks. Our drawing power was apparently significant. Dean Acheson came, Justice Brennan came, and then there was the time I invited a young senator from Massachusetts. The other clerks gave me a lot of grief for selecting John F. Kennedy in 1958, but I assured them this fellow had a big future. In 1957, most of the small group of 18 clerks had lunch together almost every day in a room set aside for that purpose. Conversations covered lots of ground, and frequently one or more of us would urge the others to take a careful look at a cert petition that we thought was a strong candidate for Supreme Court review. The law clerks were first given a room for lunch during the 54 term after some justices overheard clerks talking about cases in the public cafeteria. The 2014 court, on the other hand, had no lunchroom for the clerks, and today's clerks never have lunch together as a full group, and rarely even in smaller groups. I think that change is a loss, not just in collegiality, but in opportunities for useful exchanges. A final fact about the clerks: 7 of them have become justices of the court themselves, including this year's appointee Neil Gorsuch, who was the first former clerk to serve alongside a justice for whom he clerked, Justice Kennedy. I turn now to the justices themselves. First, their number. There were 9 in 1957 and 9 in 2014. But the number has not always been 9. The first court, appointed by George Washington in 1789, had 6 justices. Congress increased the number to 7 in 1807, to 9 in 1837, to 10 in 1863. Size was reduced to 9 in 1866, to 8 in 1868, and back to 9 in 1869, where it has remained ever since. Although the number of justices is the same today as it was in 57, there has been a marked change in their backgrounds. In 1957, only 2 justices, John Harlan and Charles Whittaker, had previously served on a federal court of appeals. William Brennan had served on a state Supreme Court, and in 2005 and for the next 5 years, all 9 justices had been judges on federal courts of appeals before their appointment. That pattern was not broken until 2010 when Elaine Kagan came to the court after serving as United States Solicitor General. And for the 23 years from 1991 to 2014, there were always at least 6 justices who had been judges of federal court of appeals, 8 in 2014 and 8 today. I think the appointment of so many former federal appellate judges is unfortunate. Although you would not expect me, of all people, to suggest that a federal court of appeals judge would not make an admirable member of the Supreme Court. My point is that the court benefits from an array of justices with varied backgrounds, especially political experience. On the 57 court, 2 justices, Hugo Black and Harold Burton, had been U.S. senators. Earl Warren had been a governor. Tom Clark had been the U.S. Attorney General. William Douglas had been a professor at the Yale Law School and chairman of the Securities and Exchange Commission. And Felix Frankfurter had been a professor at the other law school. I should acknowledge that on the 2014 court, Justices Scalia, Ginsburg, Breyer, and Kagan had been full-time professors before their appointment, and some of the others had taught part-time. The 57 court comprised 9 white men. Thurgood Marshall became the first black justice in 1967. Sandra Day O'Connor became the first woman justice in 1981. The court in 2014 included 1 black justice and 3 women. 3 justices were Jewish and 6 were Catholic. In fact, a remarkable feature of the 2014 court is that no member of the court was a Protestant. A complete change from the court during most of the 19th century, when all 9 justices were Protestant. How the justices were confirmed has also significantly changed. We are now so used to televised hearings of nominees before the Senate Judiciary Committee that it is worth recalling the earlier practice. No nominee even attended a Senate hearing until Harlan Fiske Stone was briefly questioned in 1925. The next to attend was Justice Frankfurter, who showed up in 1939 but declined to answer any questions. Questioning of a nominee resumed in 1955 with John Harlan, and extensive grilling began in 1959 with the nomination of Potter Stewart. Of course, it was the hearing for Robert Bork in 1987 that significantly changed the hearing process, probably forever. The rejection of Bork, however, was not the first time the Senate failed to confirm a nominee for the court. Before Bork, rejection was more frequent than you might have thought. 36 nominations were not confirmed, although that represents 31 people because some were nominated again, and 6 of those 31 were later confirmed. That leaves 25 people not confirmed. And the Senate's refusal to hold a hearing on President Obama's 2016 nominee, Merrick Garland, increased the number not confirmed to 26. The output of the court has significantly changed. As you may know, the court has discretion as to which cases it will accept for review, with rare exceptions such as appeals and reapportionment cases. That is quite different than the federal courts of appeals like the one on which I serve. Anyone who loses in a federal trial court can take an appeal to a federal court of appeals, and we are required to hear every one of them. The Supreme Court, however, chooses which cases it will hear. As long as the case involves an issue of federal law, such as an interpretation of the Constitution or some federal statute, the case is eligible for Supreme Court review. Issues of state law remain for decision by state courts. The number of cases the Supreme Court is asked to review has been steadily increasing over the years. The 57 Court was asked to review nearly 1,400 cases and granted review in 110 cases. The 2014 Court was asked to review more than 7,000 cases, but granted review in only 68 cases. Despite this five-fold increase in the number of requests for review, the output of the court has actually declined. The 57 Court decided 117 cases with full opinions. The 2014 Court decided only 76 cases with full opinion, about two-thirds as many as the 57 Court. In between those years, the court's output hit a high of 167 in the 1981 term and has declined ever since. Although the number of cases decided has decreased, the length of the court's opinions has significantly increased. In the 50s, the median length of Supreme Court opinions was 2,000 words. In the 2009 term, the median length was more than 8,000 words. You're no doubt familiar with Parkinson's law. Work expands to fill the time available for its completion. Apparently in the Supreme Court has a variation. Opinions expand to fill the time available to write them. Which justice wrote the most opinions? Well, in the 57 term, counting majority, concurring, and dissenting opinions, Justice Harlan led with 35, closely followed by Justice Douglas with 34, Justice Frankfurter with 31, although 14 of the Douglas opinions were 3 pages or less. In the 2014 term, Justices Scalia, Thomas, and Sotomayor were tied with 28 opinions. As is well known by tradition, not rule, the votes of 4 justices are sufficient to grant a request for review. Even when 4 justices might vote to hear a case, they sometimes decline to do so because they anticipate that if the case is accepted for review, they will be outvoted 5-4 when the case is decided. The 4 might prefer to wait for a case presenting the same issue, but with stronger facts supporting their side of the issue. Or, if there is a vacancy on the court, the 4 might prefer to wait for the arrival of a 5th justice who might vote for their side of the issue when it arises in a similar case. Occasionally, if there are only 3 votes in favor of granting review, another justice will cast a so-called courtesy vote on the theory that if 3 colleagues feel strongly the case should be reviewed, that justice should supply a 4th vote. The courts in 57 and 2014 differ in a minor way with respect to the internal procedure for informing the staff about the disposition of cert petitions reached at the weekly conference of the justices. In 57, after each conference, the Chief Justice called the clerk of the court to his chambers, and with the chief's personal clerks present, would announce which petitions had been granted and which denied. Sometime after 57, the junior justice was assigned the task of reporting cert petitions and denials to the clerk of the court. That earlier practice led to one bizarre occurrence during my clerkship. A prisoner named Harold Rogers, sentenced to death for murder, sought review of a decision limiting the authority of a district court to hear new evidence in a habeas corpus proceeding he had brought. He was claiming that his state court conviction violated his constitutional rights. I recommended to the Chief Justice that the court grant Rogers' petition, and he seemed inclined to do so. So when the Chief Justice reported the cert orders to the clerk of court, he said Rogers' petition had been denied. Soon as the clerk left, I reminded the Chief Justice this was a petition he favored granting. Oh, yes, he said, I think Felix suggested we just add some language to the denial order. Warren telephoned Frankfurter, wrote out the words Frankfurter wanted added, and silently showed them to me with the phone still at his ear. The words explained that the court understood the Court of Appeals to have ruled that the habeas corpus judge could generally accept the state court's findings, but the words said nothing about hearing new evidence. I thought the words were inadequate because Rogers wanted the federal judge to hear new evidence that his confession had been coerced. With just seconds to keep the case and Rogers alive, I scribbled the added words, quote, "and may take testimony." Warren read my words to Frankfurter, who for some reason I never understood or asked about, agreed to them. That is how an order was issued stating that certiorari had been denied because the Supreme Court understood the Court of Appeals to have said exactly the opposite of what it had really said. The outcome provoked 3 law review articles commenting on the Supreme Court's aberrational procedure of reversing while denying certiorari. The case continued before an understandably perplexed district judge and later came back to the Supreme Court, which ruled on the merits that the confession had been coerced. Ultimately, the state permitted Rogers to avoid the death penalty, and he was eventually paroled. The 2 courts differ on when they file their opinions. The 57 court followed the earlier practice of filing all opinions only on a Monday. That practice changed in 65 when the court began to file opinions on 2 days a week, especially in the final weeks of the court's term. And the 2014 continued that practice. I can take some slight credit for that change. During my year as a clerk, the correspondent for the New York Times was Anthony Lewis, then the nation's best journalist covering the court. A tradition later continued for the Times by Linda Greenhouse and now by Adam Liptak. Tony Lewis and I discussed the problems created for the press by the court's habit of filing many important opinions late in June, only on a Monday. I broached the matter to Chief Justice Warren, and he was receptive to adding opinion filing days and suggested the idea to the court. Justice Frankfurter was strongly opposed. Hearing of his opposition, I had the temerity to suggest to him that more than one opinion day a week would help the press explain the court's work to the public. He told me that was none of the court's business. Soon after he died in 65, the court abandoned the Monday-only filing of opinions. The court's communication with the public has significantly changed. Before 54, oral arguments were not recorded. During the 54 term, the future Chief Justice, Warren Burger, argued a case for the government in his capacity as Assistant Attorney General. A dispute arose as to whether he had made a concession during his argument. As a result of that controversy, Chief Justice Warren ordered all arguments to be recorded. However, for several years, those recordings were not available to the public. Only the justices and their law clerks could hear them. In later years, researchers could hear them at the National Archives, and still later, the court made recordings from one term available to the public at the beginning of the next term. Then, starting in 2010, the court made the recordings available to the public at the end of each argument week. And in 2013, recordings going back, bear with me, one of the 1950, why are these pages stuck? Here we go. Going back to 1955 were digitized, and those recordings were made available to the public online. And starting in 2006, transcripts of oral arguments have been released within hours of each argument. The court's increased willingness to let the public hear the oral argument stands in sharp contrast to its adamant refusal to let the public see the arguments via television. The justices have advanced several reasons against televised arguments. Some of them have expressed concern about becoming more recognizable and increasing security risks. Others have said the public will get a distorted view of how the court functions, both because oral argument is only part of the process of presenting cases to the court, and because TV stations will air only snippets of an hour-long argument. And concern has also been expressed that some justices would be tempted to grandstand for the viewing public. I think none of these arguments has sufficient validity to outweigh the enormous public benefit of letting the public see oral arguments. I'm delighted you agree, at least some of you. I agree there would be increased recognition, but many justices already show up frequently for televised interviews, and even without live television, their photos are flashed on the TV screen while a reporter recounts some of the more interesting exchanges. It is likely that some newscasts would air only snippets, but the print media now inform the public of only small portions of arguments, and public understanding has not thereby suffered. And as for the risk of grandstanding, my guess is the TV cameras would have the opposite effect. Justices, I think, would be less inclined to provoke laughter, either at the expense of counsel or even their colleagues. In all 50 Supreme Courts of the country, in all 50 state Supreme Courts, arguments are televised with no adverse consequences. The benefit would be significant. I would not predict high ratings for a typical Supreme Court oral argument, but interested viewers would come to appreciate that the justices are engaged in a serious enterprise, the serious enterprise of probing to understand the lawyer's arguments and discussing the issues among themselves on the bench before private conference. C-SPAN could be expected to air oral arguments in full, at least in major cases, and even a chance to see excerpts would have a great educational value. The conduct of oral arguments has changed since the 57 term. The court then allowed each side an hour for argument, except for cases placed on the so-called summary calendar, which each side got half an hour. By 2014, the court had changed its rules to allow a half hour for all cases. However, the court has allowed extended argument for a few major cases. For example, the case challenging the Affordable Care Act was argued for 6 hours over a 3-day period. The modern practice stands in sharp contrast to the court's earlier decades, when there were no time limits on oral arguments, which sometimes lasted for several days. Lengthy written briefs were then unknown. More significant than the change in time for oral arguments is the change in the extent of the justices' participation. A recent study meticulously counted and analyzed the number of words spoken by the justices and by lawyers in arguments before the 57 term, shortly after the 57 term, and shortly before the 2014 term. The results are startling. In the early years' arguments, counsel frequently began with long, uninterrupted statements, some running hundreds of words, and after a brief question or two, followed with more long, uninterrupted statements. In 61, the earlier years, one lawyer gave his entire argument for more than half an hour without interruption. But in the later years, the authors of the study report, quote, there were few cases in which counsel was able to say more than a sentence or two before being interrupted. The average in the earlier years, on average, the justices spoke for only 1/4 as many words as counsel did. In the later years, the justices spoke nearly 2/3 as many words as counsel did. And in the more recent arguments, the justices frequently interrupt each other and ask several questions in a row before counsel could answer the first one. During the 57 and 2014 courts, both the 57 and 14 courts continued the practice of filing all the terms' opinions in argued cases before the end the court adjourns for the summer. On the last day, the Chief Justice states, quote, all cases submitted to the court for decision which are ready for disposition have been acted upon by the court, or a variation of that phrase. That phrase, ready for disposition, obscures an interesting maneuver. If the court is not ready at the end of a term to file a major opinion in a case that has been argued, the case is set for re-argument at the beginning of the next term in October, and an order is entered. That rarely happens, but occurred at least once to very good effect. In June 1953, the court was not ready to file opinions in the historic school desegregation cases. At that time, the court was divided on the outcome. It has been widely reported, based on the justices' papers, that Justice Frankfurter urged re-argument for the specific purpose of gaining support for the eventual ruling. The court ordered re-argument and asked for a briefing on 5 detailed questions. The delay had a significant consequence that affected the outcome. During the summer, Chief Justice Vinson, who was not prepared to rule segregated schools unconstitutional, died. After re-argument in December, the new Chief Justice, Earl Warren, persuaded the recalcitrant justices to reject the separate but equal doctrine, and he then wrote the historic opinion in Brown v. Board of Education, which was filed in May of 1954. The decision would not have been unanimous had the case been decided in June of 1953. The court's normal practice of filing all opinions before the summer recess has one unfortunate consequence. In the rush to file all opinions before the term ends, the court occasionally permits some ill-advised language to remain in majority opinions. All 13 federal courts of appeals file opinions during the summer months, and I believe all the state courts do that too. I suppose there's some slight virtue in assuring the justices a 3-month restful summer, perhaps so they can come here, for example. But I think a slight interruption of a 3-month vacation would be tolerable. With modern technology, the justices could easily exchange views for finalizing opinions without reassembling in Washington. Indeed, the court on rare occasions has reconvened during the summer recess to hear and quickly resolve emergency matters. There are 2 well-known examples. On June 15, 1953, after announcing a recess, the court considered the application filed by Julius and Ethel Rosenberg to obtain a last-minute writ of habeas corpus to avoid execution, and the court denied it the same day. On June 24, 1971, the court heard argument in the Pentagon Papers case, and 4 days later permitted their publication. The membership of the 1957 court bears one striking resemblance to the membership of the 2014 court. Both courts had a 4-member liberal wing, a 4-member conservative wing, and 1 justice in the middle. The liberals in 57 were Warren, Black, Douglas, and Brennan. The conservatives were Frankfurter, Burton, Clark, and Harlan. The man often in the middle was Charles Whitaker. I need not remind this knowledgeable audience of the name of the 4 liberals, the 4 conservatives, and often the swing voter in 2014. The name begins with K, and it's not Kagan. I do not mean to leave the impression that either court routinely divided along liberal and conservative lines. They did not. Indeed, of the 117 opinions of the 57 court, 28 were unanimous. And of the 76 opinions in the 2014 court, again, 28 were unanimous. But both courts issued a number of 5-4 decisions, 20 in 57, 19 in 2014. And when both courts divided 5-4, the liberal and conservative blocs were often intact, but not always. Some unusual voting alignments occasionally occurred. In the 57 term, the members of the 5-member majority affirming 1 conviction were Warren, Black, Clark, Burton, and Whitaker. In 2014, the members of 2 5-member majorities were Roberts, Alito, Ginsburg, Breyer, and Sotomayor. But in most important cases, the blocs were usually intact, and the swing voter determined the outcome. 2 5-4 decisions of the 57 term raised the most fundamental issues considered that term. They both concern the power of Congress to denationalize a person, that is, to take citizenship away from a native-born citizen. The cases were Perez v. Brownell and Trope v. Dulles. In surprising outcomes, the court voted 5-4 in Perez to uphold a law removing citizenship from a native-born citizen for voting in a foreign election. And on the very same day voted 5-4 in Trope to declare unconstitutional a law imposing loss of citizenship as a punishment for wartime desertion. In Perez, the court upheld denationalization as a reasonable exercise of Congress's implied power to regulate the nation's foreign affairs. But in Trope, the court invalidated denationalization, ruling it a cruel and unusual punishment in violation of the Eighth Amendment. In these two 5-4 decisions, Justice Brennan voted for both results. Outcomes he acknowledged were, quote, paradoxical. But in many 5-4 cases in 57, Justice Whittaker cast the key vote. Unlike the able Justice Kennedy, whose vote was often decisive in many of the 5-4 decisions of 2014, Whittaker was a jurist of modest accomplishments. He found the task overwhelming. When some of us told a Whittaker clerk one day that their justice looked nervous, the clerk said, "You'd be nervous too if you were deciding every case in this building." The most interesting aspect of the 57 swing voter was the way his vote was sought by the two blocs. No fair damsel was ever courted more assiduously. It was embarrassing. My favorite recollection concerned a particularly difficult case, Harmon against Brucker. The question was whether the military could give a soldier a less than honorable discharge for misconduct occurring before he joined the armed services. It was the court's practice to vote at a Friday conference on cases argued the previous 4 days. At the first conference after Harmon was argued, no votes were cast. The case remained undecided at the next two conferences. With no justice voting even at the fourth conference, Justice Whittaker stunned his brethren at the conference by saying, "Chief, how about I try my hand at a draft?" 8 hypocritical voices, having no idea what Whittaker had in mind, chorused, "Charlie, that's a great idea." A few weeks later, Whittaker circulated a draft opinion. It was just awful. Poorly reasoned and poorly written. "What the hell is this?" we asked the Whittaker clerks. Their reply, "We're seeing it for the first time just as you are." For several days, no justice said or wrote anything. They were all determined not to offend the object of their affection. Finally, Justice Frankfurter acted, and he did so in an astonishing way. He took Whittaker's draft opinion to the print shop in the Supreme Court building and had the opinion reset with triple spacing. Then Frankfurter applied his pen to the Whittaker draft and, in the manner of a schoolteacher, crossed out all the wrong words and inserted words that made sense. Frankfurter circulated the revision to the entire court. I could not believe he would so humiliate another justice, but I was sure he was clueless about how his handiwork would be perceived by Whittaker and by the other justices. It was a failing of the brilliant Frankfurter that he could be so unintentionally tactless. Case was ultimately decided in an unsigned opinion, ruling that the discharge was invalid. As far as I am aware, the two blocks of the 2014 court engaged in no similar courtship of Justice Kennedy. Indeed, the late Justice Scalia took just the opposite tack, going out of his way to use hostile language that was certain to drive Kennedy away. In his dissent in the same-sex marriage case, Justice Scalia famously wrote, quote, "If I ever joined an opinion for the court that began," and here he quoted the first sentence from Justice Kennedy's opinion, Scalia continued, "I would hide my head in a bag." Scalia managed to insult both Kennedy and the 4 justices who had joined Kennedy's opinion. Chief Justice Warren's plurality opinion in the Trope case provides the basis for comparing the 57 and 24 courts in two respects. The first stems from the well-known sentence in his Trope opinion defining the Eighth Amendment, a sentence frequently quoted in whole or in part in many Supreme Court majority opinions, one as recently as March of this year. Warren wrote, quote, the amendment must draw its meaning from the evolving standards of decency that mark the progress of a maturing society, unquote. That sentence from the 57 term, declaring that the meaning of cruel and unusual was not limited to the original meaning in 1787, prompted an extraordinary retort from Justice Scalia in the 2014 term. In his dissenting opinion in Glossop v. Gross, Scalia said the Trope case, quote, has caused more mischief to our jurisprudence, to our federal system, and to our society than any other that comes to mind. Warren's opinion in Trope and Scalia's opinion in Glossop exemplify the fundamental divide between those who view the Constitution in some respects as a living document, adaptable to new conditions, and the so-called originalist view that the Constitution means today exactly what it meant in 1787 when it was adopted. I say the so-called originalist view because no originalist really believes that every clause of the Constitution means today exactly what it meant then. Of course, a person still has to be 35 to be eligible to become president, and every state still gets just 2 senators. But even Justice Scalia agreed that the 14th Amendment should not be understood in the 20th century to perpetuate the separate but equal doctrine of the 19th century. Another example, the Fourth Amendment prohibiting unreasonable search and seizures originally meant that only searches conducted pursuant to a general warrant were prohibited. But Justice Scalia agreed with the modern court that unreasonable searches now means any search where the state's legitimate law enforcement needs do not outweigh the individual's reasonable expectation of privacy. And it is fair to ask, was Scalia warranted in the scorn he directed to Warren's view that the cruel and unusual clause evolves as society's views mature? If, as Scalia claimed, the only punishments that are cruel under the Eighth Amendment are those that were cruel in 1787, why did he think the arms that people are entitled to bear under the Second Amendment are not limited to muskets? Some clauses retain their original meaning, some do not. Reasonable jurists can differ as to which are which. In fact, there was little, if any, talk in 1957 about originalism. Those critical of the Warren Court's liberal decisions usually argue the court was not observing appropriate judicial restraint. Warren's Trope opinion also reveals another difference between the court's view in the 57 court and Justice Scalia's view in the 2014 term. Warren surveyed the law of the nations of the world, then numbering 84, and his opinion reported that only 2 used taking away citizenship as a punishment for desertion. Decades later, Scalia would argue vehemently that it is improper even to cite foreign law in interpreting our Constitution. What is noteworthy about Warren's reference to foreign law in Trope is that not even the 4 dissenting justices at that time expressed the slightest concern that he had done so, nor did any contemporaneous commentary. Indeed, in a 2005 opinion, Roper v. Simmons, ruling that the death penalty could not be imposed on those under the age of 18 at the time of their crime, Justice Kennedy pointed out that almost all the other nations took the same position, and Kennedy cited Warren's reference to foreign law in Trope. Of course, in his dissent in Roper, Justice Scalia said, the invocation of foreign law, quote, should be rejected out of hand. My final comparison of the Supreme Court then and now takes me back a few years before the 57 term to 1952, when the court decided the Steele seizure case. That case is often recalled because of Justice Jackson's well-known concurring opinion, which the court discussed in the 2014 Zivotofsky case. The steel seizure case, many will recall, was a challenge to President Truman's seizure of the steel mills on the eve of a nationwide strike. The case presented a major confrontation between the executive and legislative branches. In his concurring opinion, Justice Jackson divided presidential power into three categories. In the first, the president acts pursuant to the authority of Congress. In that situation, said Jackson, the president's power is at its maximum. In the second category, the president acts in the absence of any statute that either authorizes or prohibits his action. In that situation, said Jackson, the president must rely on his own independent powers. But he added, there is a zone of twilight in which he and Congress may have concurrent authority. In the third category, the president acts contrary to the will of Congress. In that situation, said Jackson, presidential power is, quote, at its lowest ebb. And he can rely, quote, only upon his own constitutional powers minus any constitutional powers of Congress over the matter. To succeed in the third category, Jackson added, the president's power must be both exclusive and conclusive on the matter. In the steel seizure case, Jackson, agreeing with the court's unanimous decision, said President Truman's seizure of the steel mills was in the third category because it was in violation of an implied prohibition of Congress and unlawful because it was beyond any exclusive power of the president. The 2014 case, Zivotofsky, if I'm pronouncing it right, also presented a conflict between the executive and legislative branches. Menachem Zivotofsky was born in Jerusalem. His mother asked the U.S. Embassy to list Israel as her son's place of birth on his U.S. passport. The American embassy refused, relying on a State Department policy stating that while the place of birth of a United States citizen born abroad could normally be recorded as the country having sovereignty over the city of birth, Menachem's birthplace would be recorded as Jerusalem, not Israel, because the United States did not recognize any country as having sovereignty over that city. However, in a 2002 statute, Congress included a provision that sought to overturn the State Department policy and permit the place of births like Menachem's to be listed on a passport as Israel. The mother sued, invoking the congressional enactment. A divided Supreme Court ruled the statutory provision unconstitutional because it was an impermissible encroachment on the exclusive power of the president to recognize foreign states and their territorial boundaries. In reaching that decision, the court invoked Justice Jackson's concurring opinion in the steel seizure case. In Zivotofsky, as in the steel seizure case, the court placed the president's action in Jackson's third category because the president had again acted contrary to the will of Congress. But this time, the court upheld the president's power. It ruled the action was within the president's exclusive recognition power, and the act of Congress was therefore unconstitutional. Jackson's much-cited categories in the three categories in steel seizure provide a useful framework for beginning analysis of presidential power. But I doubt that they get us very far. All cases in the first category, where the president acts in accordance with an act of Congress, are clear. Most cases will be in the second category, and Jackson told us nothing about the standards he would use for testing presidential action when Congress has neither authorized nor prohibited such action. Jackson's third category, where Congress directly or impliedly prohibits presidential action, also provides little basis for determining outcomes, as the opposite results in steel seizure and Zivotofsky, both in the third category, illustrate. If you will permit me to express a minor heresy, I think Jackson's three-category analysis reveals somewhat less than meets the eye. I am much more enthusiastic about his most frequently quoted judicial sentence. In Brown v. Allen, he wrote the best aphorism ever applied to the Supreme Court. Quote, "We are not final because we are infallible, but we are infallible because we are final." So well said and so true. I close by recalling one of my favorite passages in all of rhetoric, Jackson's opening statement for the prosecution at Nuremberg. I urge you to read it either for the first time or again. Here is the last sentence of the first paragraph. "That four great nations, flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason." That seems like a good note on which to end the Robert H. Jackson Lecture.
We will take questions for about 20 minutes. I would note that following the lecture, Judge Newman is signing his book over at the Hall of Missions. The books are for sale over there, so if you're interested in a copy, please stop by. So because there's somebody at this mic, we'll start over here.
Does it work? No?
Hold on.
Tell me.
Thank you very much for your lecture, sir. I really appreciate it. I want to note that you mentioned that decisions these days tend to be much longer than the decisions produced by the Warren Court. I would also offer that many of the Warren Court decisions have been subsequently reversed. So my question is, would it have been more difficult to reverse the Warren Court decisions if they'd been a little bit longer, do you think?
No. I also don't think the length has anything to do with reversals. Actually, there are few of the Warren Court decisions that have been reversed. Indeed, one of his most famous dissents in the Perez case, where he dissented, the later court agreed with him and said that citizenship could not be taken away from a native-born citizen. I don't think length correlates with that at all. I think they are writing more, frankly, because they've got all those law clerks, and they write long opinions, and the justices are just too busy to cut them down. I don't think it has anything to do with the outcome of the case. Yes, ma'am. Oh, over here, I'm sorry.
Hello. I wondered if you could address you mentioned the appointment process of Supreme Court justices, and we've been through this recent experience with the refusal of the Senate to confirm Barack Obama's appointee, and we know that, and in media reports we hear about refusal to appoint district court judges and things like that, and it seems that the appointment process has become very politicized. Do you feel, or do you have concerns that somehow will impair the authority of the court and the respect that it commands? I mean, the respect that it has gotten in American society. To me, that the Supreme Court is, and the federal judiciary as a whole, is this bedrock of our system of democracy. And I really worry that that the political fighting that is going on outside of the court is taking some of the luster off of the court. And I wonder if you could speak to that. Do you have concerns about that? How do you feel about that as a judge?
I think I'd answer it this way. I share your concern, but I don't think the concern is new. I think it's existed for the entire history of the federal judiciary. George Washington appointed people from his party. Jefferson appointed people from his party. District court nominations have historically been the prerogative of the senators from the home state. Politics has been part of federal judicial appointments throughout the history of this country. Now, the one respect in which politics does not intrude, the federal judges are appointed. The state judges in most states stand for election. So once they get there, albeit under political auspices, they do not have to face election. And that, to some extent, depoliticizes the situation, unlike state courts, where they're always fearful about re-election. I think you're right to point out that there are the two camps. The Democratic presidents appoint Democratic like-minded judges. Republicans do the opposite, although there are notable exceptions. Oliver Wendell Holmes cast a key vote that was astonished Woodrow Wilson, wasn't it? Teddy Roosevelt. Oh, that's right, the antitrust case. Holmes just astonished Teddy Roosevelt. Earl Warren, after the Brown v. Board of Ed came down, was reported of saying one of the greatest mistakes he ever made was appointing Earl Warren. David Souter was said to have disappointed the president who appointed him. So it's not a neat one-for-one correlation. Bottom line, sure, politics enters into the process, but it's not politics in the traditional partisan politics sense. There are just hundreds and hundreds of cases where the people who were appointed by a Democratic president joined with those appointed by a Republican president, vice versa, to reach results which were contrary to what you might have expected them to do. They are still trying to give you their best judgment what the Constitution means. So politics is there. It's not partisan politics. They're not running for office. They do come to court with views, but they're not applying, I believe, their personal views. But they do have a point of view, a legal point of view, and if you come from a liberal tradition or a conservative tradition, those basic legal points of view are different. And there's also a pendulum that swings back and forth. So when the court goes through some liberal years, it goes over to some conservative. Now going into some conservative years, take the long view, it will go back the other way. I got to go this way, yes.
Hi, thank you. Can you give us some idea what you think will be the difference with Neil Gorsuch on the bench as opposed to Scalia?
Did you hear the question, what will be different with Justice Gorsuch on the... in outcomes, nothing. I think the votes he will cast will be virtually the same as Justice Scalia would get. I do think one difference will be he will not use the language that Justice Scalia used, which was totally uncalled for on a number of occasions. It just was inappropriate coming from the highest court or from any court. You just don't use language like that with respect to your colleagues. I'm quite sure Neil Gorsuch would not do that. He's been an appellate judge for, 10 years, never came close to using hostile language. So the language will be better. The outcomes, I think, will be essentially the same. Yeah.
Your Honor, a terrific lecture, and I've never heard anything like this before, even in law school. And
now there's better than law school. I like that.
Should the Congress establish in law qualifications for membership on the Supreme Court?
Interesting question. Should there be congressionally enacted qualifications, Supreme Court? I guess I'd like to see a set before I voted yes or no on that one. And frankly, I don't have a great deal of confidence what that set would look like coming from a Congress of the modern times. I think what they would try to do is hem a president in to achieve some political ends. So while I take your point that maybe if the set of qualifications was drafted by a commission headed by you, it would be a very high-minded commission. But I'm afraid it would be intensely political in the legislative process. And I think really, since I don't know what that set would look like, a little fear of the unknown enters my thinking. I think I'd rather see the president deal with the president's advisors and come up with hopefully the best appointments. And I think the appointments over the life of the court have generally been quite distinguished.
How about membership in a state?
Oh, I'm sorry. I got overruled. That happens a lot with me. Yes.
Thank you. Given your experience in the legislative branch before you went into the judicial branch, I wonder if you could just expand a little bit on the point you made about the difference or the lack of legislative experience in today's court compared to the two senators, former senators who served on the first court that you referred to.
Yeah. Well, I have to admit, I can't really put my finger on a precise difference. It just seems to me that people with varied backgrounds bring their varied experiences to the decision-making process. So and whereas if you take a Supreme Court of all federal appellate judges, they're really in a rather narrow point of view, and they're used to handling a narrow set of issues. So I like some former judges there. I think that's good. But I'd like a governor, a senator, a mayor. I like breadth of experience so that when they're talking about issues in the conference, somebody can say, you know, you got to understand, that governor, he had these problems. That senator had these problems. It's a matter of bringing background and point of view. I'm not so sure I can say, you know, this case would have come out differently. I don't want to overstate it. But I just think in any decision-making body, whether it's the board of the Jackson Institute, the board of Chautauqua, I think you want some variety of background, personality, everything. I think it serves the purpose. I'm going this way?
Yes.
Okay.
Along the same line, what do you think has been the effect of the change in religious composition of the Supreme Court?
What will change?
No, what has been the change as a result of the religious diversity or non-diversity of the Supreme Court?
Now, I'm sorry, do you mean, excuse me, do you mean...
I mean that you made the reference to the fact that in the 19th century it was 100% white men who were Protestant.
Yes.
Now we have 6 Catholics or former Catholics and 3 Jews.
Correct. But are you asking what's the significance of that?
Yeah. Or do you think there is a significance?
Oh, I don't think I could point to a significance in outcomes. It's hard to know because you're asking what somebody would have done had he been somebody else, and that's a hazardous prediction. I simply thought it interesting historically to point out that there has been a shift in religious backgrounds. But I would not argue that I can point to outcomes that were different today. I think when outcomes reflect, let's say, a somewhat more modern view, let's take the same-sex marriage case. That would not have come out the same way in the 19th century. But not because those were Protestant justices and these were Catholic and Jewish. It came out differently because it was decided in 2014 and not in the 19th century. And the views of the country were different. So I think it's the population shifts, things happen in the real world, the justices are not blind to those things. Those are the changes that have the greatest impact, not changes in religion, as far as I can tell. Yeah.
Thank you, Your Honor.
We're just gonna, these 2 here and these 2 here. We'll cut it off.
I have a different question.
Sure.
I had the great pleasure of going to law school in the 60s, and even then, Brown versus Board of Education loomed large. Given your relationship with Chief Justice Warren, did he ever share with you any thoughts or feelings about that decision with the time that had elapsed when you were with him?
That's an easy question. The answer is no. We never discussed it. I know a bit about the preparation of the opinion because a very close friend of mine was his law clerk at the time of that decision, but whatever was discussed at that time remains confidential.
Yes, Judge, I was wondering if you could share with us any opinion that you wrote as an appellate judge or even as a district judge that was affirmed by the court and of which you are most proud or which you think was the most significant.
Well, what? Well, I was asked something similar to that yesterday, and my first answer was, I don't take pride in any particular decision. I do like it when I write something that I think is a little better written than something I wrote 10 or 15 years ago. But I don't think pride is the measurement that for me is relevant. But your question raises a different dimension, and that is importance. And I have no doubt that of all the decisions I've written, and I think they're now, 1,300, they're an awful lot. I've been doing this 45 years. I think the one that probably had the most jurisprudential significance was the first one I ever wrote as a district judge. I was a member of a 3-judge district court in Connecticut that heard the challenge to the Connecticut statute banning all abortions without exception. And the reason that case was significant is it came to us before the Supreme Court had decided Roe against Wade. So we had to go first. And I knew it was an important case. I thought it was probably going to the Supreme Court. What I could not anticipate, but found out later from a well-known book by Professor Garrow, is that when that case got to the Supreme Court, this is from their papers, several of, at least a few of the justices commented to each other specifically on what I had said in my opinion. I don't want to overstate this. I have no illusion that what I wrote affected the outcome. That would just be preposterous. They voted the way they voted. But some of their language, I think, had some slight impact, perhaps mostly in saying that the point at which the state's interest becomes sufficient to do significant regulation occurs at the point of viability. As the case was first presented to them and before the re-argument, viability wasn't even in the picture. My opinion talked about viability, and they talked about viability of the ultimate opinion. So I think to that extent, it was a useful point of reference for them to think about that concept, but I would have no illusion that affected the outcome, not at all.
Thank you.
Thank you, Your Honor. I was wondering if you could comment on the changes you've seen over the years as far as access by self-represented parties and by parties with disabilities from 40 years ago to today. Like what changes have you seen that have helped more people to be able to bring their cases to court? Well,
Clearly, there has been a huge increase in the number of unrepresented people that come to the courts. There are lots of reasons. There are new statutes that are designed to protect rights that were not protectable 30 and 40 years ago. There's the advent of public interest law firms or law school clinics that take up many of these cases. There's a tradition now that's developing to have legal aid societies. You may recall the Johnson administration created neighborhood legal service organizations to supplement formal legal aid society. There's ferment in the area of having the unrepresented have a chance to get in the courthouse door. In the immigration field, our Chief Judge, Bob Katzman, has been active in fostering representation for the unrepresented in the immigration field, which is a source of hundreds and hundreds of cases around the country. So it's a growing area. I have to caution at the same time that it's a growing area, it remains true that those without money are vastly ill-served by the judicial system in this country. Not enough of them have access, and particularly those who are caught in the sort of low income but not poverty-stricken area, but that's true of so many areas of law. If you're poor enough to get Medicaid or poor enough to get food stamps, you're probably going to get legal aid. But if you're just above the line, you're not going to get legal services for free for the most part. But you're not going to be able to afford a lawyer either. So it's that segment of the population that is not well served by the judicial system. But we have made improvements. All the courts, including the one I serve on, has staff that when they get papers from unrepresented people, they in effect become their lawyer. Our staff in the court writes a better brief for those people than if they had a lawyer, I guarantee you that. So I think it's an improving area, but it's one that has a long way to go.
Thank you, Judge Newman. I was going to ask whether there's any mechanism to remove Supreme Court justices for being senile, but I thought maybe there was a more serious
I hope prospectively.
Well,
you don't mean
I don't remember. I don't remember.
You don't mean present.
Anyway, the question I think that concerns me about the whole process that you've gone through, about clerking and the wonderful years of experience and being part of the district appeals court, et cetera, et cetera. Are Supreme Court justices so set in their ways, I'm just trying to be judicious here, by the time they're appointed to the Supreme Court, that they are unable, intellectually or emotionally, constitutionally unable, to change from being an originalist to treating the Constitution as a living doctrine?
That's a hard one to answer. I'd answer it this way. I don't think you can likely see profound change in the approach of somebody appointed to any court, whether the Supreme Court or my level or the trial court. On the other hand, they do not remain static. We're all human beings, whether we're on the court or not on the court. We read, we hear, we learn, we get educated. I know much more about the immigration issues today than I knew 30 years ago because of some education I have gotten along the way. So if you'd put that to me 30 years ago, I would have honestly said, I know nothing about it. Now I know a lot more about it. So they're not so rigid that they're immune from education. On the other hand, you're not going to see profound 180-degree turns, I don't believe. Who you appoint matters. Who you elect as president matters, to put it mildly. But there is growth, and some justices have acknowledged that in later cases they decided to abandon a vote they cast a few years before. There are recorded instances of that. So it is not a static process, but don't expect 180-degree turns either.